Okay, let's get into it. We are about to step into what is, I think, one of the most slippery and, honestly, fascinating areas of criminal law.
Absolutely.
Imagine a crime that exists before any real harm is done, before a bank is robbed, before a shot is fired, maybe even before a concrete plan is totally locked down.
You're talking about conspiracy.
Exactly. And to frame this, there's a quote from Judge Learned Hand that just nails it. He called conspiracy the darling of the modern prosecutor's nursery.
That is such a classic, and he called it that for a reason. Conspiracy is what we call an anticipatory offense. It lets the state jump in really early.
Way before the bad thing happens.
Right. But that creates this core tension that we're going to wrestle with today. How can the law punish people for a crime that hasn't happened, a crime that might never happen?
Yeah, it feels like we're getting dangerously close to, punishing thought crimes.
It does. It really challenges the boundary between just thinking bad thoughts and actually doing bad things.
Okay, so to guide us through this murky water, what's our analytical roadmap? How are we going to break this down?
Well, we have to look at the huge advantage prosecutors get here. We'll start with the actus reus, the act itself, which is the agreement, and we'll get into the whole unilateral versus bilateral problem.
Okay.
Then we'll hit the mens rea, the mental state, specifically the dual intent requirement. That's going to lead us straight into the supplier problem,
Which is?
which is where we ask, when does a normal shop owner become a criminal conspirator?
Got it.
And finally, we'll look at the overt act requirement and a real doctrinal headache, conspiracy to murder.
And just for a bit of context, this idea isn't new, right? This came from somewhere.
Oh, not at all. You have to go way back to the Poulter's case in 1611. Before that case, you generally needed a completed crime. But Poulter's set the precedent that the agreement itself is the gist of the offense.
So the handshake is the crime.
The handshake is the crime, even if you never get any further.
All right, let's dive into that handshake then. The act of conspiracy. If no crime was actually committed, my first question is, where's the act? People just talked.
And that's the thing. The general rule is the agreement is the act. It stands in for the completed crime. And this is important. It doesn't have to be a written contract.
Not signed in blood.
No, not at all. It doesn't even have to be spoken out loud. A tacit understanding is enough. If we both look at a bank vault and I just nod at you and you nod back.
And we both know what that nod means.
That's it. That tacit understanding is the actus reus. Done.
Okay, I want to test that rule right away with the scenario from the texts. It's the feigned agreement problem.
Ah, yes. A classic for a reason. Let's hear it.
All right, so person A wants to burglarize a store. He goes to person B and asks for help.
Okay.
But person B is, let's say, an undercover cop. Or maybe he just secretly wants to get A in trouble. So B says, yeah, I'm in. He plays along completely.
But he's faking it.
Totally faking it. He has zero intention of helping. He's just feigning agreement to trap A.
Right. So on the outside, it looks like a deal. But on the inside, B's mind is innocent.
Exactly. So let's analyze this. First, what are the legally dispositive facts?
The key facts are simple. A solicits B. B communicates agreement back to A, so it looks like a pact. But B secretly lacks the intent to commit the crime. The agreement is feigned.
So what's the core legal issue here?
The issue is whether a conspiracy can even exist if one of the two parties is just faking it. I mean, do you need two genuinely guilty people to form a conspiracy?
And what's the rule the law applies here? I know there's a big split.
There is. You have to contrast two very different approaches. There's the traditional common law bilateral rule, and then there's the modern model penal code, or MPC unilateral rule.
Bilateral versus unilateral.
Right. The common law says you need a bilateral agreement, meaning two guilty minds. The MPC takes a unilateral approach, focusing only on the one defendant's guilt.
Okay, thank you. So let's do the elemental analysis, step by step. Under the old common law, how does the court apply that first element, the agreement itself?
Under common law, the agreement element requires a true concurrence of wills, a real meeting of the minds.
Which we don't have here.
Exactly. Since B is faking, there's no union of criminal purpose. A thinks there's an agreement, but he's mistaken. So under that rule, the agreement element fails. No conspiracy.
It takes two to tango, and B is not really dancing.
Perfect analogy.
But what about the other way? How does the MPC look at this through the lens of element 2, the defendant's individual culpability?
The MPC just flips the whole script. It says, forget about B's secret thoughts. Let's look only at A's mind.
And what do we see there?
We see that A has manifested a firm purpose to commit a crime. Did A agree? Yes. Did A believe there was an agreement? Yes. A's own personal guilt isn't lessened just because he picked an unreliable partner.
So after that analysis, what's the final conclusion?
You get a split decision based on where the crime happened. Under the traditional common law, A walks. No conspiracy. But under the MPC, which is the modern trend, A is convicted.
Wow.
The MPC punishes A for his own dangerousness, not for the danger of the group.
That is a massive difference. You're a felon or you're free, all based on your partner's secret thoughts.
And think about police work. Under common law, you can't conspire with an undercover cop. Under the MPC, you absolutely can.
Okay, let's pivot from the act to the mind. The mens rea. You mentioned a dual intent. I want to zoom in on the second part of that. The intent to achieve the objective.
Right. This is where things get really tricky for, say, legitimate businesses.
This is the supplier problem.
The supplier problem. One of the toughest areas because it brushes up against normal, everyday commerce.
Okay, so lay out the general rule for us. When is a business on the hook?
So, conspiracy is a specific intent crime. The rule is that just knowing your buyer might use your goods for something illegal usually isn't enough.
Just knowledge isn't enough.
Right. The prosecution has to prove the seller had a stake in the venture or a specific intent to, help the crime succeed.
Let's make this concrete. We've got United States v. Falcone, a classic Prohibition-era case. Let's analyze it. First up, the dispositive facts.
In Falcone, you have defendants who are wholesalers. They sold things like sugar, yeast, and tin cans.
Well,
And they sold them to people they knew were bootleggers making illegal alcohol. But, and this is key, sugar and yeast are what the court called innocent articles of free commerce.
so what was the core legal issue?
The issue is this. Does selling those innocent supplies, even with full knowledge of their illegal use, make you a conspirator?
And what rule did the court apply? Can you break it down into its elements for us?
The court used the rule that knowledge alone is not proof of intent. The rule requires that the defendant must promote the venture, make it his own, or have a stake in its outcome.
So what are the elements to test for?
We're looking for two things. First, an intent to promote the illegal goal. And second, we look at the nature of the goods being sold.
Right. Now for the elemental analysis. How did the court handle that first element, the intent to promote?
The court looked for any evidence that the sellers actually cared if the bootleggers succeeded, and they found nothing.
They just wanted to make a sale.
That's it. They wanted to sell sugar. They didn't care if the distillers got caught tomorrow as long as the check for the sugar cleared. Their interest ended right there at the cash register. No stake in the outcome.
Okay, understood. Now what about that second element? The nature of the goods.
This was huge for the court. They kept emphasizing that these were innocent goods. Sugar has tons of legal uses. Selling it isn't automatically suspicious. The court was really hesitant to start policing the sale of staple goods.
Right, you don't want every grocer to be a detective.
Precisely.
So after weighing all that, what was the court's final conclusion?
The court concluded that the suppliers were not guilty of conspiracy. The big takeaway is that knowledge does not equal intent.
Okay, so just because you know doesn't mean you've agreed.
Not so fast. The law isn't quite that simple.
I had a feeling. So let's look at the other side of the coin. Direct Sales Co. v. United States. This one feels like Falcone's evil twin. So let's analyze it. What are the facts?
Okay, so here, Direct Sales Code is a drug wholesaler. They were selling enormous quantities of morphine sulfate to a doctor in a small town, a Dr. Tate.
And by enormous, you mean?
I mean, thousands upon thousands of pills, so much that it was just impossible for one doctor to be legally prescribing it all. And this went on for a long, long time.
So what was the legal issue this time?
The issue is, when does a seller cross that line from just having knowledge to actually having criminal intent? Can the sheer volume and type of goods prove a conspiracy where Falcone failed?
And what rule did this court use? Can you break down its elements?
The court created a sort of modification to the Falcone rule. It said intent can be inferred from selling restricted commodities in quantities that are incapable of lawful use.
Okay, so the elements are different.
Yes. First, we look at the nature of the goods. Are they restricted or innocent? And second, we look at the volume and frequency of the sales, what the court called active stimulation.
Let's do the elemental analysis. How did the court apply that first element, the nature of the goods?
They drew a very sharp line between this case and Falcone. Morphine is not sugar. It's a restricted commodity, heavily regulated by law.
Which puts the seller on notice.
Big time. The court basically said dealing in dangerous controlled substances is fundamentally different than dealing in groceries. The inherent danger changes everything.
Okay, and what about the second element, the volume and frequency?
This is that active stimulation part. The quantities were so huge, the only way Dr. Tate could get rid of them was by selling them illegally. So, by continuing to supply him, direct sales wasn't just a neutral seller.
They were depending on his crimes.
Yes, they had a stake in his criminal enterprise continuing because that's how they kept making their money. They were actively feeding an illegal market.
And so, the court's final conclusion.
The court found the wholesaler guilty of conspiracy. They took that step from knowledge to intent. Falcone protects the indifferent grocer. Direct sales convicts the complicit drug supplier.
So sugar is safe, morphine is dangerous. But what if the crime itself is just truly awful? There's a visceral hypothetical in the text I want to run by you.
Oh, I think I know the one you mean, the Molotov cocktail scenario.
That's the one. Here are the facts. A gas station attendant is watching a customer. The customer is filling up glass bottles with gasoline and stuffing rags into the necks.
So, clearly making Molotov cocktails.
No question. Then the customer looks right at the attendant and says, "I'm going to burn down the elementary school." The attendant just rings up the sale, takes the money, and the guy leaves.
Yeah. This is where abstract legal rules really slam into moral reality.
Right. Gasoline is an innocent good, like the sugar in Falcone.
Mm.
But the intended crime is just... it's terrorism.
The text discussed this as a potential carve-out. The analysis suggests that while gas is normally an innocent good, the sheer gravity of the planned crime might be enough.
It lowers the bar for intent.
It sort of collapses the stake in the venture rule. The argument is you can't just say, hey, I just wanted to sell some gas, when you know with certainty it's going to be used for mass murder. It's an aggressive theory, but it shows that the innocent goods defense isn't a magic shield.
You can't hide behind business as usual when the business is abject horror.
Exactly.
All right, let's shift to our last big puzzle. Conspiracy to murder and the overt act. First off, what is an overt act, and do you always need one?
So, at common law, no. The agreement was all you needed. But today, pretty much every statute requires an overt act by at least one of the conspirators.
And does that act have to be a crime in itself?
Nope. And that's the real catch. It
Yeah.
can be a completely innocent legal act, buying a map, making a phone call, renting a car.
If it's in furtherance of the plan.
If it's in furtherance, it counts.
Okay, but here's the real headache. Conspiracy to murder. We all know murder comes in different degrees. First degree, second degree. So can you have a conspiracy to commit, say, second-degree murder?
This question creates a fantastic logical puzzle.
We see a conflict in the cases between People v. Horn and People v. Cortez. Let's focus on Cortez, since it seems to be the modern rule. First, what are the legally dispositive facts?
The defendants in Cortez agreed to kill someone, but at trial they argued they lacked premeditation and deliberation, maybe because they were drunk or had diminished capacity.
So they were trying to knock it down.
Exactly. They were trying to get the charge lowered to conspiracy to second-degree murder, which the older Horn case had allowed.
So what was the core legal issue for the court?
The issue was, is it even legally possible to have a conspiracy to commit a non-premeditated murder? Is conspiracy to commit second-degree murder a coherent legal concept?
And what rule did the Cortez court lay down? What were its elements?
The court in Cortez established a very bright-line rule. All conspiracy to commit murder is punished as first-degree murder, period. The reasoning has two key elements. First, agreement as premeditation, and second, basic logical consistency.
Okay, let's do the elemental analysis.
Mm-hmm.
How did the court treat that first element, agreement, as premeditation?
The court's logic was that you can't suddenly agree with someone. An impulsive, unplanned killing, that's often second-degree murder. But an agreement, that takes time. It takes communication and reflection.
So the act of agreeing is itself premeditation.
The court said yes. By the time you have talked about it and formed a pact to kill, you have, by definition, premeditated.
That makes a lot of sense. And what about the second element, logical consistency?
Well, the court just pointed out that the phrase conspiracy to commit second-degree murder is a contradiction in terms, a logical impossibility.
How so?
Second-degree murder often implies a lack of a thought-out plan. But a conspiracy is a plan. The court basically said, you can't plan to be unplanned. The agreement itself proves a shared, deliberate intent to kill.
So after analyzing all that, what was the court's final conclusion?
The court in Cortez flatly overturned Horn. The defendants were found guilty of conspiracy to commit first-degree murder. The holding is that once that agreement to kill is formed, the highest level of intent is automatically established.
Wow. So the moment you shake hands on murder, you're on the hook for the most serious charge.
That's the rule.
We have covered so much ground here. From sugar sales to Molotov cocktails. For the listener trying to keep this all straight, could you synthesize this into a diagnostic checklist for us?
Absolutely. Here's a 5-point framework for spotting and analyzing conspiracy.
Okay.
1. The agreement. First, look for a tacit understanding. Don't waste time looking for a formal contract. A nod can be enough. 2. The parties. Ask yourself, is this a common law or an MPC jurisdiction? Common law needs 2 guilty minds, the bilateral rule. MPC only needs 1, the unilateral rule. So your defendant can be guilty even if his partner is a cop.
3.
3. The intent. Remember, it's dual. Did they intend to agree? And did they intend for the underlying crime to happen?
4.
4. The supplier test. Is this a Falcone situation with innocent goods and mere knowledge, which means acquittal? Or is it a direct sales situation with restricted goods and high volume, which points to conviction? 5. The overt act. Look for any act, no matter how small or innocent, done in furtherance of the plan. If one person does it, everyone in the group is on the hook for it.
That is incredibly helpful. And I want to leave our listeners with one final provocative thought from the reading about the impossibility defense.
Oh, that's a good one to end on.
So if you and I agree to pick someone's pocket, and we go up to them, but it turns out their pocket is completely empty, have we still committed conspiracy?
Yes, absolutely. The agreement is the crime. The fact that it was factually impossible to actually steal anything doesn't matter one bit. You agreed to commit the theft, and that's the danger the law is targeting.
So in conspiracy, the thought, once shared, really does count as the deed. That is a heavy note to end on. Thank you for walking us through all of this.
My pleasure.
And thank you for tuning into this deep dive. Stay safe and maybe be a little more careful about who you agree with.